This is an introduction to federal courts, part of Unit 5, Court Civil Rights and Civil Liberties. This slide provides an overview of the American legal system. It gives you just some basic terminology to help you understand the different kinds of cases that are tried, so you can read the terminology there in front of you. I'm not going to read it all directly to you, but it just gives you an idea of some basic structure. Okay, Constitution. The Article 3 establishes the judicial branch. The only court that's mentioned in the Constitution is the United States Supreme Court. All other lower courts are lower federal courts. Every court under the Supreme Court was established by Congress. The Judiciary Act of 1789 was what created the first series of additional courts beyond the Supreme Court. Legislation. A law is currently what sets the number of Supreme Court justices, the position of Chief Justice. So that's why we've had a varied number of Supreme Court justices, from anywhere to as few as 6 to as many as 15 during FDR's court packing plan. And district courts are the courts of original jurisdiction. And these are the courts that these are your trial courts. They're going to hear the case. Any case that's going to start in federal court will be heard first at a district court. And then if there are grounds for an appeal, they might go to an appellate court. There are currently 94 district courts. Each state has at least one. Texas, I believe, has 4. And then you have appellate courts, which were created to help take some of the load of hearing appeals off of the Supreme Court that were created in 1891. And then you have legislative courts, which deal with issues regarding taxes, trade, international trade, bankruptcy, very specific courts for very specific purposes. Okay, so this just shows you there are 11 appellate districts in the United States, and this is just a map that shows you the geographic boundaries of the United States Court of Appeals. So you have your district courts, which are your trial courts. If a case is decided in a district court and there are grounds for an appeal, if the case is originally tried in Texas, then it goes to the Fifth Circuit Court of Appeals for its first appeal, and that would take it to New Orleans, Louisiana. Original jurisdiction is the court where the case must first be heard. So, for example, district courts or the courts of original jurisdiction, you cannot have, let's say, a felony offense committed and then immediately have that case tried in the Fifth Circuit Court of Appeals. They have to begin in the trial courts or in the district courts. And then if there are grounds for an appeal, they can file the appeal in the Fifth Circuit Court of Appeals if it's in Texas, Louisiana, etc., where you saw the map previously, or any other district. And then if there are grounds after the first appellate court, you might be able to get your case to the Supreme Court. So appellate courts are made up of 3 federal judges. They hear the cases in their respective circuits, and it's not just one judge that's making the decision, it's the majority. So 2 of 3 have to decide together in order to make a ruling. And then if a case goes to the Supreme Court's jurisdiction, they may or may their case may actually not be heard. The vast majority of appeals to the Supreme Court are never heard, but the Supreme Court is the only court in the United States that has both original and appellate jurisdiction. Original jurisdiction involves cases with ambassadors, foreign ministers, consuls, or if a state is a party in a case. So if Texas and Oklahoma, the state governments of Texas and Oklahoma sued each other for whatever reason, that would be a case that could have original jurisdiction in the Supreme Court. Very, very, very few cases have truly had original jurisdiction in the Supreme Court. It's extremely rare. And then concurrent jurisdiction are cases that might be tried either in state or federal courts, because we have a dual court system, and that means that we have 2 different court systems that are working at the same time. We have a federal court system which was created under the Constitution of the United States, and it deals with the law of the United States and treaties. It involves cases among different states or citizens of different states, and either a state or federal court can review a case if both state and federal laws are broken. State court systems deal specifically with issues that are violations of state law, anything that basically belongs specifically to that state. And once you go through the legislative process in the particular state, because states have their own state Supreme Courts cases, or they have their state Supreme Courts, then if the proper criteria are met, once a person has taken their litigation from a state district court, all the way through that state's Supreme Court, then they could possibly file an appeal with the Supreme Court of the United States. Federal judges are appointed for life. The president appoints, the sitting president, when there's a vacancy in a federal judgeship, appoints or nominates a person to be a federal judge, but they have to be confirmed by the Senate. And this is one of the reasons why they're given life terms, as long as they have good behavior, which means basically that they are not committing any crimes or ethical issues. Even if it's not necessarily a crime, they could be impeached for unethical behavior. The reason the framers gave federal judges lifetime appointments is because they didn't want them to have to be reelected. They didn't want them to be subject to political pressure. They wanted judges to be able to interpret the law. And this is where senatorial courtesy comes into play, particularly if the president is appointing a judge to a federal judge position in a state. There are 4 federal district courts in the state of Texas, and so the senators from Texas would be given senatorial courtesy. They would be able to suggest to the president names of judges that they think might work well for Texas. Obviously, right now we have 2 Republican senators and a Democratic president. So when there were federal judge positions open in 2009, shortly after President Obama was inaugurated, the senators from Texas were not so much given senatorial courtesy, but that is an option. So the process of nominating a Supreme Court justice is very, very thorough. Most of the nominees that make what's called the short list have been vetted by the FBI. They've had thorough background checks conducted to make sure that the president isn't going to be embarrassed by his or her nomination, because they don't want someone with a skeleton in the closet to come out during confirmation hearings. Presidents consider party affiliation, but federal judges are supposed to be sort of apolitical. They're not supposed to talk about politics and their beliefs while serving as a judge. But obviously, presidents are not going to appoint someone who is the other side of political ideology. And so during confirmation hearings, members from both political parties get to ask questions about their stances on major issues. They look if they have prior judicial experience, which pretty much all of them do, to see if they've made decisions, and they look at prior decisions to determine whether or not they think this person is going to be too crazy, liberal, or conservative, whichever one may be. In the past, or not in the very recent past, presidents have started considering their race, gender, religion, region of the country that they're from, to try to provide a more diverse Supreme Court that's more representative of the American people. And then basically what happens is that presidents end up having to come up with a somewhat seemingly moderate candidate to nominate for the Supreme Court, because if you're a president and you nominate someone that's really liberal or really conservative and you don't have the political affiliation or senatorial courtesy on the Senate Confirmation Committee, you're not going to get your justice appointed. And so you have to make sure that you try to find a balance for not being too extreme in either venue. What's happened recently, though, is that Presidents Obama and President George W. Bush have both appointed judges that haven't had a great deal of controversial ruling, so it's very hard to tell just using the litmus test in these confirmation hearings exactly how they're going to decide big cases. So we're not really sure how liberal or conservative some of these recent appointees are. As with all of the branches of the United States government, there are checks and balances that are placed on judges, and so our legal system is operated as an adversarial system. You have two parties, an issue that's between two parties that are decided by an impartial judge or juries, and you have a justiciable dispute, which means that it's an actual situation and not a hypothetical test. So a lot of court cases get thrown out because they don't have justiciable dispute. You can't have a hypothetical situation. It's got to be a real thing. Political questions, arguments between the president and Congress, which, as we talked about previously when we talked about the president and Congress, the way that the Constitution is set up, they're just not always going to get along. And then appointments. The president appoints the Senate the president appoints federal judges with Senate approval, and then judges can be impeached, so that's their incentive to make wise decisions while on the bench and not do anything illegal. And the structure of the courts can be altered by Congress. The number of district appellate courts, because the district and appellate courts were both created by Congress, as well as the number of Supreme Court justices is determined by law passed by Congress, so all of those things can be changed by Congress. The only thing that is in the Constitution that could not be changed by Congress is the existence of a Supreme Court. The size is something that Congress has the authority to change. And then constitutional amendments can be made to overrule a federal court decision, which can check or limit the power of the federal courts. This is just a picture that shows you the current 9 Supreme Court justices. What's interesting is that Congress determines their salary, the number of justices, but the salaries are the same for the Speaker of the House is the same salary that the Chief Justice is paid, so it's $217,400 the last time I checked. The federal government gives a cost of living adjustment sometimes every year. They haven't recently, so it could be a few $1,000 off, and then $208,100 salaries for associate justices, which is a great deal of money. But if you consider the fact that justices such as Elena Kagan worked at Harvard Law, and deans in law schools make between $300,000 to $400,000 on average, then they really are taking a pay cut to be a Supreme Court justice. Okay, so the Supreme Court process of accepting cases, you have original jurisdiction, which is very, very, very small number of cases throughout U.S. history. It's cases involving ambassadors, foreign ministers, consuls, or a state and a party, other foreign nations, basically. So anytime the United States government has a legal dispute with, let's say, a Native American tribe, because those are considered sovereign nations, they would be subject to original jurisdiction in the Supreme Court. Very few cases. Most of the Supreme Court's legal docket is made up of appellate cases. They have approximately 10,000 appeals or writs of certiorari to try to get the attention of the court to get on their legal calendar. Only about 100 out of approximately 10,000 cases a year are heard. If the Supreme Court does not give the appeal standing, then the lower court decision remains, whatever ruling that is, that stands. And if justices feel that there is a conflict of interest, they may recuse themselves, which means they just excuse themselves from that particular case. The rule of 4 is how cases get on their docket. So 4 of the 9 justices have to agree that for some reason the case that they're considering has merit and should be heard. There's a decision that needs to be made about that particular issue that the court has not already addressed. One of the reasons why it's so hard to get a case heard by the Supreme Court is because the court likes to let legal precedents or